This presentation on bioethical decision-making in psychiatry. Our objectives are to discuss the ethical principles that guide decision-making when we are providing mental health care. We're going to compare and contrast legal versus ethical issues in the care of psychiatric patients. We're going to identify situations that warrant emergency custody orders, ECOs, and temporary detention orders, or TDOs. And we're going to discuss some ethical dilemmas that we commonly encounter in the care of psychiatric patients. So what is the meaning of ethics and morals? Well, ethics and morals. Ethics is the study of ideal human behavior and ways of being. It is an active process supported by logic and theoretically based arguments. We encounter a lot of bioethical issues in psychiatry. But ethical conflicts, they occur between people or people with values. They're in conflict with other people who have different values. So it's best to kind of step back and view ethics through our professional roles and responsibilities, and really look at ethics in terms of the ethical principles of autonomy, beneficence, non-malfeasance, fidelity, veracity, and justice. And we're going to talk about each one and how they are applicable in psychiatric nursing. So autonomy. Autonomy generally trumps all. It rules, because we must advocate for our patients so that they can maintain their ability to self-rule. So whenever we are administering or helping people with advanced directives, helping them to make informed decisions, helping to facilitate shared decision making, providing them with representation, possibly if they're undergoing some type of a legal procedure when they are on a psychiatric unit, or making sure that they know their choices or their options, then we are protecting their autonomy and their ability to self-rule. Beneficence kind of falls right next to autonomy, so there's a reason why these are in order. Beneficence is all about doing good, do the right thing. And this certainly comes into play and can trump autonomy when a person lacks the capacity to make their own decisions. And when I say they lack their own capacity to make decisions, it's about medical decisions when we're in a clinical setting. It's not about their personal affairs, but about their ability to make decisions about their medical care. In order for someone, though, to lack capacity, there has to be someone available to act as a surrogate decision maker, and the surrogate decision maker has to have the person's best interest at heart. So in the clinical setting, the medical providers we are only charged with determining a person's capacity to make decisions about their health care. We are not determining whether they are competent individuals. That is a legal term and one that's decided by the courts. With beneficence, though, you have to be really careful to avoid paternalism. And when I say that, I mean you've got to set aside really what you think is best and what people should do. And, beneficence used to rule years ago when it was the doctor knows best, and you need to listen to what the doctor says, regardless of your opinion. A doctor knew what the right thing was to do. Non-maleficence is sometimes difficult to tell if it's different from beneficence, but it really is. I know your book will say that they're really interchangeable, but this is all about do not cause harm, do no harm. And so preventing medical errors. We know that medical errors are the third leading cause of death. So it's very important for us to adhere to standards of practice and to maintain safeguards in a clinical setting. So double checking when you're giving patients blood that you have two people there to lay eyes, making sure that we have armbands and, right med, right patient, making sure that people are not harmed with physical restraints is a big issue, of course, in psychiatry. Avoiding pejorative language, because that can be very hurtful to persons, and we know there's so much stigma with mental illness that we sometimes say things like the schizophrenic down the hall, and it's very important for us to recognize that there's person first language is much more respectful. So a person with schizophrenia, a person with bipolar disorder, a person with an addiction rather than an addict. So that goes to respecting someone's dignity. And all these can help us to prevent us from harming our patients. Fidelity is about loyalty. And when I say loyalty in a clinical setting, and especially on psychiatry, it's, you don't want to fall victim to a pack mentality. And that pack mentality can occur when there is a commonly held belief and we pass judgment as a group. And this can happen in the course of going through a report or the shift report. You can hear a lot of judgments sometimes being passed back and forth from the day shift to the night shift. So we need to be very careful of that and be professional and maintain good boundaries and not be judgmental towards our patients. We need to make sure that we're responsive to our patients' needs. Recognize also that our needs are important. The needs of our staff are important. So being loyal to self means adhering to your own self-care and the care of others. Making sure that you stay grounded and healthy so that you're able to present your best self, that you can respect and adhere to the interest of your patients, yourself, and the institutions where you work. And know that, if you become unhappy where you are in your position, make sure that you do not become part of the problem. So if you're unhappy, maybe it's a time to do some self-reflection, and maybe it's time to make a change if you're unable to improve the situation. Veracity is all about truth-telling. I put this picture here of the Mona Lisa. We went to the Louvre to see the Mona Lisa, one of the many exhibits, and it was interesting that it was really very tiny, and no one really tells you that until you wait in the 45-minute line to get up to see it. So, truth-telling, we need to tell our patients all about the risk and benefits of their treatment, and sometimes the risk outweigh the benefits or vice versa. So we need to tell them about all of the side effects that could occur with medications and what they can expect from treatment. Justice, fair and equitable treatment, but does everyone have access to fair and equitable treatment? We like to think that everyone has access to the same type of care when it comes to healthcare, but that's not always the case. So we have a statutory authority to treat, and if someone presents to, for instance, in the emergency department, then we are legally mandated to provide treatment. And if someone presents and they show cause that they are a threat to themselves or others, then they can be subject to an involuntary commitment. And there are many ethical and legal considerations associated with that. We need to make sure that we use the least restrictive options and before we proceed to other more restrictive options. So if a patient presents to the emergency department, and all patients need to go through the emergency department before going into an acute care facility, it has to be determined whether or not they are a threat to themselves or others. And if it's determined that they are, then they're offered a voluntary admission. If they refuse voluntary admission, then we contact an outside agency, and that is the Community Services Board, which we spoke about in an earlier lecture. The Community Service Board representative will come and evaluate the patient. They, again, are an outside entity, and they can initiate the legal proceedings necessary to have someone committed under a temporary detention order. Once someone is admitted under a temporary detention order, then they have to be seen within a 24 to 48 hour period, and they will go through a formal court hearing on the inpatient unit. They will have legal representation and will go before a judge. And if a judge determines that there's enough information that provided that shows that the person is a threat to themselves or others, then they can order the person to be held involuntarily. If they make a decision that they need to be held involuntarily, the person is still offered an opportunity to admit themselves voluntarily, take a voluntary admit, and it's usually for a shorter period of time. So it is not a small deal to have someone admitted to a psychiatric unit against their will. So if someone is admitted to a clinical setting under a temporary detention order, they're still going to have medical decision-making capacity, even though they're found to possibly be a threat to themselves or others. And in that case, they can still refuse to take medications. So sometimes you can request medications over objection, and that is only you can only get that order if the person is already under a temporary detention order. You can administer medications in emergency situations, such as if a person is very combative and openly a threat to themselves or others, and then you can administer medications on an emergent basis. So it is a big deal. So there's involuntary treatment, which we just talked about, and that's like medications over objection. The process differs from state to state as far as the process. The basic criteria, though, the person has to have a diagnosed psychiatric disorder. They have to be found to be harmful to themselves or others. They need to be unaware or unwilling to accept the nature and severity of the disorder, and we know that treatment is likely to be beneficial. So involuntary admission, there is time detained, and that varies by state. There are emergency custody orders in the state of Virginia, and ECO, or emergency custody order, is for a 24-hour period, and this can go into effect if, say, for example, a person tells a friend or family member that they are considering suicide or they're going to attempt suicide, and the family member or friend can contact law enforcement. Law enforcement can come, and based on that information and their own assessment of the situation, they can bring a person into the hospital under an ECO, and then that again is very time limited, but during that time it enables all of the players, the law enforcement and the community service boards rep, the crisis care team, to make decisions and to make arrangements and decisions to determine whether or not that person can come in voluntarily or need a temporary detention order. So here's a link to laws that are governing commitment for your review. So restraints and patient rights. Restraints are strict guidelines as far as when they can be used. Seclusion and restraint is never ever done for staff convenience or for punishment. Minimal use of seclusion and restraint for patients and environmental safety only if less restrictive means have been ineffective. And there are, Joint Commission has standards for restraints, and I believe you have a clinical lab where you learn about how to tie restraints, how to place patients in restraints securely, and to provide ongoing assessment. You need to be familiar with the rules regarding restraints and the guidelines. In your ATI book, you can see the guidelines as far as the age of patients and how long they can be in restraints. So please review these documents through Joint Commission regarding the use of restraints. So preventing seclusion and restraints is important, and you need to, as a nurse, if you're working in mental health care and really anywhere in a clinical setting, you need to be in tune to your patient's mental state and be on top of it at all times, and recognize that just with the use of good communication and a calm, caring, and gentle approach, most of these situations can be diffused without having to resort to seclusion and restraints. So we talked some about capacity and competency, and I really want to drive this point home. Competency is a legal and not a medical concept. Person is able to make reasonable judgments, and they're considered to be competent until a court rules otherwise. If a person is incompetent, then they need to have a court-appointed guardian, and this person can make health-related decisions. Competency and informed consent are connected. We need to make sure that our patients are well informed about treatments and that they know that they have a right to refuse treatment, and that if they are, though, a threat to themselves or others, then we can override their refusal to treatment. However, it can never be overridden, or their rights to refuse treatments can never be overridden based on our convenience or staff's convenience. So these are some legal terminology just to help you to understand the differences between mental capacity, consent, compliance, undue influence, and duress. Persons who have serious mental illness or chronic mental illness, where they've had episodes in the past where they've lost capacity to make their own healthcare decisions, can be eligible or to draft a mental health advance directive. And this is sometimes called a Ulysses contract, and it's mentioned in your textbook. This helps to protect a person's ability to self-rule so that they know that their wishes are going to be respected, even if they are found to lack capacity to make their decisions. So this came about out of the Patient Self-Determination Act of the 1990s, and it protects, again, patient autonomies and is legal in 25 states. So a word about privacy. Privacy, confidentiality, and privileged communication. And there are a variety of privacy types. Privacy of information, I think we're all very familiar with. Physical space, though, is different, and especially on psychiatry, where we have the big open area where patients interact with one another in the milieu. There are no private rooms in psychiatry. They're all shared spaces. And there is a lot of group therapy, and so a lot of information is shared. So it's very important for us to be mindful of that and to help our patients through these processes and to understand how their privacy is protected under those circumstances. Certainly, patients have a right to opportunity to be able to make decisions, to talk with people they need to help them to make decisions, that they have access to communication, that they can make phone calls, receive mail. However, in psychiatry, a lot of things are taken away. Your right to come and go, maybe your access to your private your phones, your own, so you can't make telephone calls always when you want to. You certainly can't use your own device. You can't have access to the personal items you brought in when you were admitted because of safety reasons. So this can be really upsetting for a lot of people. So confidentiality, we are familiar with the Health Insurance Portability and Accountability Act, or HIPAA. This is all about protecting health care information or health information of our patients because of the development of electronic medical records. Informed consent is that process for getting permission before conducting a healthcare intervention on a person, and it is under that umbrella of confidentiality. Patients need to know what they're consenting to and what the benefits or the risk and benefits are of any given treatment. We need to make sure that our patients know the limitations of confidentiality and let them know that not everything they tell us can be kept in confidence. If, for instance, a person is a threat to themselves or others, and we'll discuss some of the other instances that can be not held in confidence. So privileged communication. Privilege provides relief from having to disclose information in court proceedings. And we know this comes about with mental health records when possibly there is a child custody battle going on between a couple. They're going through a divorce, and one spouse might want to bring in someone's mental health records, and there are laws to protect the records to protect people and prevent their records from coming into a court of law and being used against them. It's important for us to know that. We also know that mental health providers can decide not to release records to patients if they feel the record contains information that might cause a person harm. So these are the exceptions to guaranteed confidentiality. Of course, if a person is a threat to themselves or others, if there is litigation, records being subpoenaed, and this, again, we need to know which records and how they can be released, and know that some records are protected. And if the person discloses that they have been abusive to children, elders, or if a person is physically or mentally handicapped, then these are situations where we need to report to law enforcement, child protection, or adult protective services. But reporting laws do vary from state to state. Healthcare providers are mandated reporters, and we must report suspected assault, neglect, and abuse. In the state of Virginia, it's if there's if you suspect child abuse, it's less than 18 years of age. If elders, meaning over the age of 65, but this might vary depending on state laws, it might be over age 60. Any individual with mental or physical handicap that renders them vulnerable, that needs to be reported if you are suspecting that they are being abused, and if a gun or a knife was involved in a particular attack. So we discussed the TerraSoft as one of the limits to confidentiality. These are about the TerraSoft laws and our responsibility to warn someone if they've been threatened by a patient. So releasing information, we cannot, if someone contacts us wherever a person is, be it in the emergency department, on a medical surgical floor, or in psychiatry, we cannot confirm that a person is a patient. We can, take information if someone wants to share something with us, but that has to be communicated with the patient. But again, we cannot provide information to someone that a patient has not provided us with consent to talk about their medical conditions. Possibly there might be court mandates to release information, but healthcare providers just cannot release patient information to any unidentified or unauthorized telephone callers without a patient's consent. So elements of informed consent, and this is important for you all to know, that all providers must document that informed consent has been obtained. And a provider is responsible for ensuring that the patient has the information that they need to be cognitively capable of giving informed consent and to give voluntary permission. So patients need to know what is the nature and the purpose of treatment. Does the patient know the risk and benefits of treatment versus no treatment? They need to know about any treatment alternatives, their diagnosis and prognosis. Here's an excellent example of black box warnings and how they come into play. We need to always be mindful of providing our patients with the information on black box warnings and to document that they were given that information, and also that they have accurate information about side effects. Electroconvulsive treatment. This is a very effective treatment which can, certainly be can create ethical dilemmas in psychiatry, especially since it has a very bad reputation, despite the fact that it is a wonderful treatment, especially for major depression with psychosis. But persons who are severely depressed are excellent candidates, but often they can be found to lack capacity to make a decision for this type of treatment, which would be, in that situation, optimal treatment, has optimal treatment effectiveness. So, safety contracts for suicidal patients, that can be a very sticky area. We always talk with our patients about what they would do should they have suicide ideations. Are they willing to be hospitalized, or do they have connections with family members? Do they have someone that they would reach out to? We need to be mindful of the resources available to indigent populations, whether they have access to their prescriptions, can they afford them? Do they have discharge instructions that they're going to be able to adhere to? And do they have adequate follow-up? And it's all about safety and responsible care and responsible discharging. So just a word about boundary issues. Always remember that your patient is the focus. We cannot accept gifts from patients, sharing personal information with our patients. It's important to avoid that. Remember the concepts of countertransference and transference, and how those can interfere with that therapeutic environment. And making sure that you set good limits, making sure also that you work with the patients on the unit to make sure that they have safe boundaries between themselves and other patients. A word of caution about negotiation: it is important to work to avoid power and control issues. Always leave room for negotiation. It's hard to be in a locked unit. Well, it's hard to be a patient anywhere you go. It's a very vulnerable position to be in. And sometimes we take away even the most basic needs. I put this picture of Tic Tacs on here because I saw an argument take place between a staff member and a patient once over a patient wanting one Tic Tac because she was on a 1,200 calorie diet. So just a word about negligence and tort cases, or it has to be, in order to prove malpractice, there has to be these 4 elements present. The duty to exercise reasonable care when providing treatment was not met. There was a breach in standard of care, and that's the big one. You didn't follow standards of care. Or a relationship existed between that breach of duty and the outcome, and as a result of the breach in care, there was permanent and substantial damages as a result. So these are some of the types of lawsuits in psychiatry: a breach of confidentiality, medical errors, giving wrong medications, safety and false imprisonment, which is the reason there are multiple steps involved before a temporary detention order is issued, and of course defamation of character. And this is libel if something is written in the notes that is very derogatory, very non-objective, and of course slander. Invasion of privacy, assault, meaning that the definition of assault is if there is a fear that someone will be touched without consent. So if you say to a patient, if you don't settle down, I'm going to give you an injection, that can be assault. Battery is actually touching someone without consent, and that of course can include forcing treatment, restraints, forcing seclusion. If there is suspected negligence, most states require there's a legal duty to report risk of harm to patients. We need to make sure that we report peers if we suspect any chemical impairment. If you smell alcohol on one of your staff members, it's important to report that, or if you suspect diversion of substances. We need to make sure that we clarify orders if an order is unclear. We can be charged with abandonment if we maybe discharge someone without follow-up, or if we walk off our unit and leave our patients without care. And again, deviations from standards of practice can be viewed as negligence of care. So bottom line, avoid liability by responding to your clients, educating your clients, complying with the standards of care. So know your policies and procedures. Supervise care if you have someone that's working under you, like a maybe a CNA or a tech. Make sure that you adhere to standards and your policies. Document carefully, objectively. If you are documenting something a patient says, put it in direct quotes. Do not make judgment statements or use pejorative language in your documentation or in communication with others. Make sure that you follow up on any interventions. If you provide somebody with pain medicine, make sure you follow up to see if it was effective. Maintain a good interpersonal relationship with the clients and with the families of your patients, of course. So in summary, the ethical principles, they provide us with a foundation for decisions regarding what is our best course of action for delivering patient care. Bioethics committees are at most hospitals, and they are available in the clinical setting, and you can request a consult as a nurse. You don't have to be a physician to order a bioethics consult. But before you ask for a consult, make sure that you can you can answer the question, what is the ethical dilemma here? Is it an issue with autonomy, beneficence, non-malfeasance? A patient's capacity to make medical decisions, we know that can fluctuate day to day. So a person might be capable or have capacity to make decisions one day, and then that improves the next. So make sure you follow standards of practice consistently, and know that patients with psychiatric advance directives are more likely to receive the care that reflects their own values and preferences. So encourage really not just your psychiatric patients, of course, but all of your patients, friends, and family members to have advance directives. Very beneficial for safeguarding autonomy. Thank you very much.